All right, well, looks like we have a good number here, so I'm going to go ahead and get this started. Thank you all for joining today's spring training event. We have some great speakers today who will talk about 3 areas of law that we think are helpful for every attorney to know a little bit more about. This event is co-sponsored by Legal Aid of Western Michigan and the Young Lawyers section of the Grand Rapids Bar. My name is Noah Joseph, and I'm part of the pro bono team at Legal Aid. And my role is to recruit and support attorneys who are volunteering their time through the pro bono program. We have a long-standing program of one-on-one case representation, which will always be the core of the pro bono program, but we are also expanding opportunities through clinics and other innovative programs. An example of this is an upcoming expungement fair that we're co-sponsoring with the Black and Brown Cannabis Guild. So please contact me if you're interested in helping with this event. Now I'd like to introduce Alex Thibodeau, the president of the Young Lawyers section of the Grand Rapids Bar. He is a litigation associate at Foster Swift Collins and Smith PC, where he practices in the areas of commercial business, insurance defense, and municipal law. Welcome, Alex.
Thanks, Noah. Thank you for everyone that took time out of their busy schedule to attend this event. This is the first of a number of events that we, as the Young Lawyers section, have planned in support of Legal Aid and in support of our West Michigan legal community. Really, the mission of the Young Lawyers section is twofold. It's to support our lawyers within our legal community, and particularly our young lawyers, giving them direction, education, networking opportunities, experience-based programming, essentially. And then the other side of that is really supporting the West Michigan community at large. And really one of the best ways to give back to that community is going to be through volunteering with Legal Aid or pro bono organizations like that. The Legal Aid of West Michigan provides a significant amount of help and access to justice for thousands of West Michigan patrons. So we really appreciate all the work that you do and hope to have an ongoing partnership with Legal Aid through the Young Lawyers section. So with that said, we encourage you to get involved with Legal Aid of West Michigan. And if you qualify as a young lawyer and you're not already a member of the Young Lawyers section, meaning that you are under 36 or in your first 5 years of practice, I would strongly encourage you to get involved, become part of our section, and participate in all of the awesome things that we have planned for this year. With that said, I'll send it back to Noah. Thank you again for coming to this and perhaps all 3 sessions today, and I'm sure they're going to be very, very educational. Thank you.
Thank you, Alex. Now let's jump right in. We will be moderating the chat, so please enter any questions that you have and we'll get them answered. And also, I just should let everybody know that we are recording today's event, so we will hopefully be able to post this later if you know of other folks that are interested in viewing it. The first session today will be on expungement and the changes that have been enacted under the new Clean Slate Law. Speaking today will be Professor Tracy Brame, the Associate Dean of Experiential and Practice Preparation for Cooley Law School. She is the immediate past president of the Grand Rapids Bar Association and on the board of Legal Aid of Western Michigan. She started the Access to Justice Clinic at the Grand Rapids campus in 2006, oversaw the West Michigan Public Defender Clinic, and now leads the Cooley Innocence Project. Prior to Cooley, Dean Brame spent time at Legal Aid of Western Michigan, Public Defender Services for the District of Columbia, the Federal Defender Office, the State Appellate Defender Office in Detroit. She began her legal career as a law clerk to the Honorable Julian Abel Cook Jr. in the U.S. District Court in the Eastern District of Michigan. Tracy received both her BA and JD from the University of Michigan. Joining her will be Kamal Sandiford, the staff attorney for the Access to Justice Clinic with Cooley Law School. Over to you, Tracy and Kamal.
Thank you so much. I'm very happy to be here. I should probably start by saying today, go blue. right? You heard my double alma mater there, headed to the Sweet 16 this weekend. So I love everything about this event. I love the theme, spring training. I'm a huge sports fan. I love that it's a young lawyers event. And though I am neither 36 nor 5 years, I'm way more than 5 years out of practice. I love that you all are taking up the mantle, and it looks like our future is in good hands. I brought a young lawyer with me today, just for some representation. In part because Kamal and I have been tag teaming really for the last 5 or 6 years. He is in many, many ways, my boots on the ground. As you heard Noah kind of recite my various roles at the law school, and they have taken twists and turns. And my latest iteration is running the Innocence Project, which is very different than expungement work. So Kamal is whom I consider the expert. And so he's going to be here to help me tag team and just say a little bit about him. He's a graduate of WMU Cooley Law twice. I had him as a JD student back in the day, where he had to endure me mentioning to him countless times that he had the same name as my son. And so I was like, come on, just like my son. And then he also got his LLM from WMU Cooley as well, and joined me in the clinic about 5 or 6 years ago. And again, has been invaluable since then. So we're gonna, kind of tag team today. And as some of you may know, our Grand Rapids campus of WMU Cooley is closing as of August of 2021, so in just a few months. And with that, unfortunately, our expungement clinic in its current iteration is closing as well, which makes me very sad, because we've been able to do some really great work in that area. But it also makes it all the more important that you all are learning these skills and learning the new statute. So in some ways, it's good timing, right, with the statute being amended. And so hopefully we'll have a whole new crop of lawyers, volunteer and otherwise, who are learning the new statute and able to help area citizens, West Michigan citizens, navigate kind of this new world. So again, thank you for being here. I'm going to try my best to continue this work in some form in Lansing. Still try to figure out how to do that. But in the meantime, thank you to Noah, to the Black and Brown Cannabis Guild, to the young lawyers, to Kamal, to everybody who is filling that space right now. What we're going to do in the next 45 minutes or so is really going to be an overview. Noah alluded to an event that's coming up next month, that an area clinic for expungement, and leading up to that will be a much more comprehensive training and kind of teaching you all how to screen these cases, et cetera. It would be impossible to go too in depth in the statute in the next 45 to 50 minutes. Just in part because it's not because it's overly complicated, but just because there are kind of a lot of different factors that can go into any one person's case. And so, I want to give you an overview of the statute, and mainly an overview of what's different, right, from the prior statute. So what you can look out for. I'm going to say at the beginning, and Kamal can attest to this too, when you do this work, right, be prepared to read the statute thoroughly, and to have some pencil and paper, right, to chart out everybody's case individually, because as I'll talk about in a minute, we used to only be dealing with one conviction. Then we were dealing with, right, maybe 1 felony, 2 misdemeanors. And under the new statute, fortunately, people can maybe address, several more convictions than that. But figuring out what those convictions are, the timing of them, the classification of them, can be complex at times. And so, just make sure that you're taking your time with these cases and taking the time to learn the statute, so that you're not wasting yours or the client's time either going into court prematurely or with less than a full view of the facts, right? So I'm going to talk just very briefly about the evolution of I'm going to share my screen, about the evolution of expungement law here in Michigan, and then kind of get right into the new law. So when we first started doing this work at the end of 2014, you could only have one conviction, like one and only one. Didn't matter if it was a misdemeanor or a felony, one conviction in order to be eligible to even go into court and ask for an expungement. So needless to say, that was a very restrictive statute, and relatively few people were eligible under that statute. In January of 2015, the Michigan legislature expanded that statute to make eligible people who had no more than 1 felony and 2 misdemeanors, right? So that expanded the field greatly. We at the clinic had a couple of relatively high profile events trying to educate the community around the new statute. And those couple of events, right, gave us a 2-year waiting list, essentially, right, of people, just from people who were ineligible under the old statute, but eligible under this new 1 felony, 2 misdemeanor statute. So it was just, again, groundbreaking for folks. And, around the time I moved to Grand Rapids in 2003 or so, there was already, even at that time, more attention being paid to collateral consequences of criminal convictions, right? To the notion that people, even after they served their time, even after they paid their fees and they finished probation and parole, they were still facing significant barriers, right? Based on their criminal history. And those ranged, of course, from, we often hear about employment barriers. We had, folks get out of prison with kind of crushing child support debt, folks who were having trouble finding housing, signing up for, loans for education, even going on their kids' field trips, right? So, there have been a bipartisan effort over the years to kind of address that. And that effort intensified as the job market opened up and, right, area companies in particular, were needing more and more to find employees. And so, then came this bipartisan effort that was buttressed even by the private sector to, kind of do something about these collateral consequences, kind of do, something for folks who were still, having paid their dues, so to speak, we're still facing barriers. So out of that, rose this 1 felony, 2 misdemeanors, and it's been that way for the last 5 or 6 years. But of course, we were still finding that was relatively restrictive. Those of you, anyone who does practices criminal law, or even those of you who do legal aid work or any kind of pro bono work, know that unfortunately it's incredibly easy, right, to pick up cases. And if you do, right, pick up criminal cases. And if you do, particularly as a young person, or you go through a phase in your life, if you have one, right, conviction, it's not, it's likely that you're going to have 2, and it's not uncommon to have several, right? So even with the 1 felony, 2 misdemeanor eligibility, we still had a lot of people who had outgrown, right, whatever had caused them to have the criminal history in the first place, who had moved on, who were trying to do something with their lives, who were still feeling the brunt, right, of these collateral consequences. And again, this issue just got an increasing amount of attention. Michelle Alexander wrote a groundbreaking book several years ago called The New Jim Crow, just talking about the impact of collateral consequences on civil rights, et cetera. So hence, again, a renewed push to push our Michigan legislature to open up, right, the world of eligibility a little bit more. So just really, really great advocacy on the part of many, many organizations and people, notably Safe and Just Michigan, just really kind of pushing for, what they consider justice for folks who again, were trying to do the right thing, but we're still being hampered. And so finally, in October of 2020, Governor Whitmer signed the Clean Slate Act. And, again, it was a long time coming. It had been in the works for a while. It had been passed by the House, got hung up in the Senate. Over a couple of issues, and then, of course, was affected like the rest of our world by the pandemic. But finally, in October, we got movement on it, got a bill passed, and that bill will be effective in just a few weeks, right? In just a few weeks. So Kamau and our clinic, right, and Kamau and the students in particular have been hard at work, kind of learn the ins and outs of the new statute, and thinking about how to get the word out to folks, right? One of the dynamics that we saw even under the old statute was that, you'd be surprised how few people knew about the statute, knew how to go about expunging their criminal history, knew who to call, knew what to do. So some folks at University of Michigan Law School, for example, wrote a white paper explaining that less than 10% of eligible people, even under, right, the prior statute, were able to take advantage, right, of the opportunity. So again, Kamau and I, and now I really say Kamau and I, because, here as we get into the weeds of it, I'm going to lean on Kamau a little bit, but we're just going to walk through just again briefly some of the major changes between the two statutes, and then really, really encourage you all to participate in the in the clinic that's coming up next month and the training that will be provided in advance of that. Okay. So what's new? Well, I'll start by saying what's not new, right? So some things don't change, and the fundamental principle behind the statute hasn't changed in the sense that it is still a discretionary statute, right? Except we'll talk about the automatic piece in a minute, right? But to the extent that you're applying for expungement for your clients, it is as judges like to tell our clients sometimes, it is a privilege, right, and not a right. So even when the clients meet the baseline eligibility, and again, we'll carve out the automatic piece in a minute, but even when they meet that baseline eligibility, the judge still has discretion, right, based on his or her determination of whether expungement is consistent with the public welfare. And they have discretion whether or not to grant, right, the petition for expungement. Another thing that has not changed, please remember, and this is important as you're talking to clients and even understand yourselves, expungement is not exoneration, right? Expungement is not exoneration. So it does not mean that the crime goes away. So now I work in the Innocence Project, and when we our role is to kind of help people who have been wrongfully convicted, who shouldn't be there in the first place, right, get out of prison and hopefully exonerate them, and for them to, at least on paper, right, go back, right, to a place where they were never convicted of this in the first place, even though they can't get their years in prison back. With expungement, it is more of a set aside of the public record itself, right? The idea being that when you're applying for a job, right, when you're doing a background check to go on field trips for your kid's school, those places don't necessarily need to know that 15 years ago you passed a bad check, right? Because that's not relevant to your current story. You know what I mean? And so that's the idea. If you reoffend, right, those convictions have not gone away. They are still relevant for resentencing. They are still, the courts are still going to know about it. They're still going to show up, in police liens, et cetera. But the idea is to set it aside from public view, right, to help people get back to a place, of more normal. And so, Kamal, I'm going to ask you as we kind of get into what's new. If you want, I might even bounce over to you to take a slide or so, to make sure that we're getting your input, but certainly to answer questions and to supplement and correct me to the extent that I misstate anything or incompletely state anything. So I'll start with the automatic expungement piece, and then maybe I will hand it over to Kamal for the next one. So one of the biggest new pieces, is this notion of automatic expungement, right? This notion that instead of having to go through this, relatively onerous process of applying, so we've had over 100 expungements, right, in the clinic. And the vast majority of them have consisted of us, working with the client to go get fingerprints taken, to get letters of recommendation, to file these petitions, to, pre-COVID drive out to the courts, take a day off of work, do all of these things to go for what is usually a 5-minute hearing, right? Because for the most part, the judges would grant these petitions. We've had, a couple of doozies where they, ended up being more complex than we anticipated, or that had, some issues that even ended up, we ended up appealing. But for the most part, these were 5-minute hearings. Sometimes if the judge was really busy, he or she wouldn't even have us appear on the record. They would just sign it right in chambers. And, again, our clients have taken a day off work or done whatever they need to do to get there. So part of this new bill is to make it easier for people and to provide for automatic expungement. Okay, so the state is going to, or the plan is that the state will come up with a system to expunge certain offenses automatically after a certain period of time. So a few important things to know about this is that, first of all, because people are going to be very, kind of curious about this. And if you look at press around the new statute, a lot of it is Clean Slate Act. Now there's going to be automatic expungement, right? Super exciting. Not at least until April of 2023, right? So that piece of it, I say not at least. The state has until April of 2023 to design this system. Maybe they do so sooner than that. With everything else going on, I would not be surprised if it took until at least then, right? But even that deadline could be extended in 180-day increments, right? Because they literally have to build a system, right? And anybody who works in systems and logistics, right, knows that this will be, quite an endeavor from an economic standpoint, from a logistics standpoint, from a technological standpoint, to design a system I'm not even sure how, it's going to work for them to automatically expunge convictions. But so that won't happen until 2023. In the meantime, the application process will be available as of next month. So you can still petition for expungement, right? But this notion of automatic expungement is probably still a couple of years away, okay? To qualify for automatic expungement, you could have no more than 2 felonies, right? Or 4 93-day misdemeanors, okay? Sorry. So the waiting period for automatic expungement, 10 years for felonies and 7 years for misdemeanors. Okay, so we'll talk quite a bit about waiting periods in the next few slides, but when the automatic expungement piece is in place, right, 10 years or 7 years after the imposition of a sentence or completion of any term of imprisonment, payment of fines, et cetera, waiting period is 10 years for felonies, 7 years for misdemeanors before a person's record is going to be expunged automatically. Okay, still a series of things, and as you may know from the current statute, right? There's, and we'll talk about that a little later. There are some things that you can't expunge for the automatic expungement piece, right? Again, because the idea is that for low level, relatively simple things, we're not going to make people go through all the effort to go to court to expunge it. Yeah, you wrote a bad check in whatever year, we'll wipe that off your record as long as you meet the criterion. But for things like assaultive crimes, serious misdemeanors, right? Crimes of dishonesty, 10-year convictions, anything that involves minors or vulnerable adults, right? Death, serious injury, et cetera, and violations related to human trafficking. Those will not be, right? Those are not among the kinds of convictions that will be eligible for automatic expungement. And again, I won't, in the interest of time, won't go through, list of terms and how to define them. I'm sure that you'll learn a little bit more about that in your training when you sign up, right, for the event next month. But there are areas in the statute that define, right, what a serious misdemeanor is, what a crime of what constitutes a crime of dishonesty, et cetera. And those are really important, right? Because instead of only looking at ICHATs, right, criminal history reports that have 1 or 2 or 3 convictions, you're going to be looking at them, ones that have several, and having to determine conviction by conviction, right, what the classification is and whether they are eligible. Okay. So I'll let Kamal talk a little bit about traffic offenses, because that's another new element of the statute.
All right. Thank you, Dean Brame. So as many of you guys may already know, under the current law, you cannot expunge any type of traffic offense. That includes DUIs, driving on a suspended license, no ops on person. Those offenses traditionally, at least under the current law and under previous versions of the law, have not been able to be expunged. Under this law, which will go into effect pretty soon, you will be able to expunge those types of offenses. So again, the driving on a suspended license, no ops on person, things like that, driving without insurance, those types of minor traffic offenses, you will be able to expunge. You still will not be able to expunge DUIs. I know that there has been some talk in the Capitol about potentially amending the statute to allow for DUI first-time offenders to have those types of DUIs expunged. But as of right now, you cannot expunge DUIs under any circumstances. And again, that may change at some point. Offenses causing injury or death. So if you have a traffic offense which causes injury or death, that cannot be expunged as well. The way I like to look at it, obviously, if you're looking at an iChat and you identify that this person has a traffic offense, as long as that traffic offense doesn't fall into one of these 3 categories, you can at least know that, yes, assuming that person meets all of the additional criteria under the new law, they would potentially be eligible to expunge this traffic offense. So the other distinction that we have to make as well is obviously you have a criminal record and the person will also have a driving record as well. If you are counseling clients, you want to emphasize to them that the expungement would not impact their driving record and whatever obligations they have with respect to the Secretary of State. Those will remain in effect. It will simply impact their criminal record, and to the extent the traffic offense poses a burden on their criminal history, that's how the expungement would impact them. All
And
right.
this is, yeah, this is, oh,
I was gonna say, a question just came in on the chat that relates to this, so I'm going to jump in if you don't mind.
please.
Asking if driving while visibly impaired is expungible.
Excellent question. Obviously, it's generally a lesser offense to the DUI. I don't know off the top of my head whether something like that would be expungible. If I had to make an educated guess, I would say no. But that's something I would definitely look into later
Yeah, definitely.
on.
And keep
we'll
those
definitely look into.
Exactly.
Yeah.
So keep
Go
those
ahead.
questions coming, because as we go through these trainings and we start to talk to people, there'll be a laundry list, right, of things that either weren't captured, right, in the bill. Because, again, anybody who knows anything about writing legislation is that, what the intent is doesn't always come through crystal clear in the final product, which is a subject of much negotiation, et cetera. So keep those kinds of questions coming, because as you see, there'll be things that need to be cleared up along the way. And Kamal's educated guess is based on this as a political issue, right? So the eligibility of traffic offenses, first of all, is huge for our clients. I can't tell you how many people would have otherwise been eligible for expungement, but for driving without suspended, right, Kamal? Like we have people, and again, right. So easy to pick up a driving while license suspended, particularly in certain areas, particularly in the inner city, particularly in the right. So those are often charges that you get when the cop feels as though he's letting you off easy. At the very least, you're going to get a driving without driving while license suspended, et cetera. Which seems like pay a fine and go renew your license, or do whatever you have to do to satisfy your license requirement. But then it ends up tripping you up, right, when it comes to trying to set aside your record, et cetera. So that was an excellent fix, right, to not have these traffic offenses hindering people who should otherwise be eligible to set their record aside. But the issue became, are we also, right, going to include DUIs, right, which, for kind of maybe obvious and political reasons are kind of a hot button topic, and this notion of allowing people to expunge convictions, even though they're, unfortunately not, that conviction is not uncommon, right? But it's like I said, a politically hot issue. And so, the visibly impaired is closely enough related to driving under the influence that an argument could be made that it would be excluded. But that, again, it's probably an open question. A great question.
I have another question. I'm not sure if it relates because it's not something I'm familiar with, but
okay.
The question is, what about 333.7411 deferrals?
7411s, right.
Oh, yeah.
So a deferral in and of itself is essentially an expungement. If that's what they're referring to, where the person goes through a program, like 7411 or Holmes Youthful Training Act, and upon successful completion of that program, the conviction is dismissed or expunged. In that scenario, you wouldn't be able to expunge a 7411 conviction, if you will, because it's theoretically already been expunged. Deferral, any convictions that have been deferred and dismissed through a program like 7411 or HIDA will count as a misdemeanor for expungement purposes. And so that's where that particular situation would come into play as it relates to the expungement statute. But in terms of actually expunging a 7411, it's already been expunged. So.
And so that's one of those places where it's really important, right, to get the whole story from your client, because the iChat is not necessarily going to tell you the extent of their criminal history. Because if they have deferred and dismissed convictions, if they have 7411 deferrals, they're not going to show up necessarily on that iChat. So you might think the person has 3 misdemeanors, right, when they really have 5 because they've had a couple of these, deferred and dismissed. So we always have the students ask the question, in addition to what's on the iChat, right? Is there anything else that you know of in your criminal history? And you always have to double check, because people don't always remember, right? Like these, folks like get 7411s when they're 18 years old and now they're 40 and they're like, yeah, I went to court for something and the judge said, go forth and sin no more, but I don't remember signing it. I don't remember what happened, right? So, really important to follow up. So Kamal, when the students, for example, always do for our clients a district court search, of wherever the client lives or might have lived, to just check and make sure that they're catching anything that might not necessarily be reflected in the iChat. Because early on, we would get tripped up by that. We go to court or we get a response from the AG's office saying, nope, actually your client has 5 convictions, right? Or whatever it might be, because we hadn't caught those deferrals. So that was a great question. An important point. So again, what's new? Importantly, misdemeanor marijuana offenses, right? So as we know, there's been moves across the country. I just heard New York is perhaps on a path to legalize recreational marijuana, and certainly that movement has been afoot in Michigan for quite some time. And as a reflection of that, the new expungement statute allows a path for folks to have misdemeanor marijuana convictions expunged. So as of April 11th, individuals may apply to have misdemeanor marijuana convictions expunged. Now, importantly, the law creates a presumption, right, that the offense was based on activity that wouldn't have been a crime had it been committed on or after December 6th of 2018, right, when our laws opened up. So again, trying to make this easier, right, and trying not to flood the courts with, a ton of misdemeanor marijuana offenses where you have to have hearings and file petitions, et cetera. The law created a presumption that can be rebutted by the prosecutor within 60 days. But if there is no response from the prosecutor, the court will enter an order within 21 days setting aside that conviction, right? So now if you have a misdemeanor marijuana offense, right, that wouldn't have been an offense, right, as of December of 2018, there's a presumption that it should be set aside. If the prosecutor responds, then the court will set a hearing, right? The prosecutor has the burden of proof by preponderance of evidence that activity would have been criminal. Does that make sense? So
I do have a question that
okay, go ahead.
That came in, although now it says maybe it was answered. With the presumption, is that based on the charged offense or the factual basis for the charge?
So again, great question. It come out, you correct me if my analysis is wrong, but I would argue that it would be the charged offense, right? So the offense that was actually charged and what the conviction was based on. So for example, I'll analogize to different kinds of offense. We've actually had cases in which, and I'm going to try to remember the facts of this, right, since I'm going to use it as an analogy, where we had a domestic violence, right, case where we had someone who wanted to expunge a domestic violence conviction, but they had 2, right? And if you have a second domestic violence conviction, you are not eligible for expungement, right, of the DV cases. But the second one was actually charged not as DV, right, but as assault, right? And so we argued, right, despite whatever the factual underpinning of the charge was, the actual charge was assault. And for whatever reason, the prosecutor charged it that way or let him plead that way, didn't matter, right? For purposes of the expungement statute, right, we went by the charged offense, and the judge, agreed with that argument and based it on what the actual conviction was, and as opposed to the underlying conduct. And you're right, that could be important in these marijuana cases where you might have a plea down to something, right? You might plea somebody to a misdemeanor offense, even if the underlying facts might have supported a higher charge. But I would argue that it's the actual charged offense. Would you agree with that, Kamal?
Yes, I would argue that as well. Although I could see the prosecutor arguing because the language says that the activity would have been a criminal violation, and they'll probably focus on that word activity and use that as justification to go beyond the record and look at police reports, etc., beyond the court record to see whether it would have been a violation or not. So, yes, I agree with you.
Exactly. Again, that's a great question, because I can see, particularly early on, getting arguments like that from the prosecutor, depending on the case. But we have had at least anecdotal success in, looking at the charges as opposed to the activity. But great question. All right. So, Kamal, you want to talk a little bit about expungement?
Yeah, so currently and traditionally, in order to get an expungement, you've always had to apply, right? You apply with the court, you then serve the attorney general, the prosecutor, the AG, etc., and then you have a hearing date in front of a judge. That is still in effect, and I know we talked about the automatic expungement process, but if you want an expungement anytime soon, within the next 2 years at least, before the state enacts this automated expungement program, you will have to expunge, or you will have to assist your client with expunging by application. All right. So what you'll see is that the waiting period, which has traditionally been 5 years, varies under this law, right? But some of the key points still remain. And what I mean by that is, whenever you apply, the waiting period must have lapsed, right? So whether we'll talk about it in a little bit, depending on the nature of the crime, it may be a 3-year wait period, it may be a 5-year wait period, or you may have a 7-year wait period. Regardless of what wait period you're working under, you obviously have to wait for that time to lapse there. The other thing is you can't have any criminal charges pending against you, obviously. There is an interesting provision in this law, and myself and Dean Brame and a number of people who've gone back and forth about this provision. It basically says that you can't have a conviction during the applicable wait period, or the court can set aside a conviction if you have a subsequent conviction during the applicable wait period. And then as far as limitations, the individual can have no more than 2 assaultive crimes expunged in their lifetime. All right. So obviously, as of right now, the statute allows for up to 1 felony and 2 misdemeanor convictions. Under the April 2021 law, it's up to no more than 3 felonies, right? So theoretically, you can have no more than 3 felonies expunged. Multiple felonies, as I touched on, the varying wait period. So if you have multiple felony convictions, there's a 7-year wait period as opposed to a 5-year wait period. If you're looking for a single felony to be expunged, you're still on that 5-year wait period track. All right. So 5 years for 1 felony still, as it is under the current law. If you're looking at multiple felonies, it's 7 years. And the 7-year wait period will begin from the most recent felony. So I'll use this as an example. If you have a 2012 felony conviction, right, then you pick up a 2015 felony conviction. You get probation for the 2015 felony conviction. You're discharged from probation in 2017 for that 2015 felony conviction. Your 7-year wait period begins from the date you're discharged from probation as of 2017 for the second felony, if that makes sense. I know it might be somewhat confusing. There's also a distinction made. So you'll see in the law, there's a distinction made between multiple felonies, 1 felony, right? So multiple felonies is a 7-year wait period. 1 felony is a 5-year wait period. But they also distinguish between serious misdemeanors and regular misdemeanors, if you will, or non-serious misdemeanors. A serious misdemeanor, for example, would be a domestic violence, right? it's still a misdemeanor, but it's classified as a serious misdemeanor under the law. And so you would have a 5-year wait period for an offense of that nature. All right. For a non-assaultive, a non-serious misdemeanor, you would be on a 3-year track as opposed to a 5-year track. So an example of a non-serious, non-assaultive misdemeanor might be a retail fraud 3rd degree, for example. You would be, or that client would be on a 3-year track as opposed to a 5-year track. And regardless of what wait period you're on, you're always looking for which event occurred last. So imposition of sentence, discharge from parole or probation, or release from imprisonment, whichever of those 4 things occurred last, that is when the wait period will begin.
And that's where you're going to be, right, kind of doing your mental gymnastics, and why it's really,
Right.
really important to sit down and chart out these, these offenses, because, like I said, once you file that petition, there's going to be an MSP report, that is generated and sent to the judge and sent to the AG, right? That's going to give, right, kind of their list of offenses and what occurred and when it occurred. And then the AG is going to base her response on, right, that MSP report and what you've alleged in the petition. So, kind of making sure that that is correct as possible on the front end is going to save your client some time, right, and save you some time. And what we found is, once it's going to take a while. It's going to take a minute to get used to this new statute, and for judges to figure it out, and for the AG's office to figure out. And once you do, it becomes more intuitive. But particularly at first, there's going to be some things that maybe have to be litigated about, what certain things mean, what the waiting period means, and when it starts, and whether there's a restart, et cetera. So
the other thing, I'm sorry.
Go ahead. No, please, come on.
The other thing I forgot to mention quickly is there's no limitation theoretically on the amount of misdemeanors that can be expunged under this law. So while there is a limitation on the amount of felonies, 3, theoretically there isn't a limitation on the amount of misdemeanors.
And again, that is huge, because I cannot tell you how many people that we had to turn away because they had 3 misdemeanors, right? And ironically, under the current statute, right, the one that, kind of that is in place until April 11th, you could have 1 felony and 2 misdemeanors, and you could expunge the felony. But if you had no felony and 3 misdemeanors, you were just out of luck, right? You were just ineligible. And so, again, unfortunately, it is not uncommon for people to have several misdemeanors. If they have 2, right, it's not unfortunate. Particularly, I see in my work often, people go through a phase, not only in my work, but in my family, right? People go through a phase in their life, right? And a misdemeanor can vary from, driving with suspended license to, some kind of disorderly, some kind of conduct that we're trying to argue is a civil infraction, but was charged as a misdemeanor. It could be any number of things. And they, the policing and prosecution of them can be so discretionary, that it was really a hardship for folks, to be won over because of a misdemeanor. So the opening up of that, right, the fact that there's now not a limitation on misdemeanors is going to make a big difference for a lot of people. Another, what I find great amendment to the statute is the one bad night provision, right? So again, as we mentioned before, when you could have 1 and only 1 conviction and be eligible, we had very few people that could comport with that, because it's not uncommon to have several charges arise out of 1 incident, right? So under the new statute, multiple felonies or multiple misdemeanors, right, will be treated as 1 felony or 1 misdemeanor if they all occurred in the same 24-hour period and arose from the same transaction, right? So if you have 1 bad night and you get caught up with something and you get arrested, and they kind of tack on the charges, but it's all based on the same transaction, right? You could treat that as 1 felony, right? For the purposes of expungement, right? You might still have 3 felonies. Like if you reoffend, that might still be your 4th felony, but for purposes of expungement, you could treat it as 1 felony. Oops. Sorry about that. Oops. Can you all still see my screen? Okay.
Yes.
Sorry, I'm sorry about that. None of the offenses, in order to qualify for this, none of the offenses can be an assaultive crime or a crime involving a dangerous weapon or a 10-year conviction, right? So again, we're talking about trying to make allowances for relatively low level, right, crimes that happen within a 24-hour period, okay? So what's the same? I see we're coming up on 12:47. So in the interest of time, I'll move a little quicker unless there are questions. So what's the same? Just like under the old statute, there are certain convictions that are excluded from expungement, right? And they include life offenses, right? You cannot, anything that was, charged as a life offense, right? That you were convicted of a life offense, obviously, even if you're out and you didn't do right life, or if you could have gotten life, you may not expunge it. Criminal sexual conduct for the most part, right? Still first, second, third degree, as well as certain other sex crimes cannot be expunged. Right. There's this asterisk exception for CSC, the fourth degree on or after January 15. But in general, CSC cases are out of bounds. And then, as I mentioned before, a felony for domestic violence if the individual has a prior misdemeanor for the same. Okay. So, Kamal, you want to take deferred and dismissed convictions, human trafficking reapplication?
I do have a couple of questions.
Right.
Oh, sure, please.
Jump in. So going back to Kamal's example, the question is, does the 2012 conviction become ineligible for expungement, or does the waiting period begin after parole or probation release on the 2015 conviction?
Under the scenario I used, you could theoretically apply to have both of those felonies expunged. The 7-year wait period, though, would begin at the end of your probation for the 2015 felony. So I think the example I used was 2012 felony, then there was a 2015 felony, and they got 2 years probation, and their probation ended in 2017. So the 7-year wait period would start from 2017. So you'd be looking at 2024 before they would be eligible to apply to get both of those expunged. I don't know if that answers the question or not.
Yeah, I think so. And then another question was that I had as well is, how do paying off of fines fit into the law?
Well, good question. So what we've experienced over the years is there's nothing in the law that prohibits the court from denying the petition because you have unpaid fines. But generally speaking, at least based off our experience, and Dean Brame, you can chime in as well, the court won't grant the expungement if there's outstanding restitution owed to the victim or outstanding court costs or fines, especially restitution, because, the court can't waive restitution, right? They could theoretically waive court costs. So if there's a situation where somebody still owes $50 in court costs, then the judge might just waive it then and there and grant the expungement. But if there's restitution owed to the victim, it's highly unlikely that the court would grant the expungement in that scenario. All right.
And then one last question so far. So for the one bad night rule, if there's a felony charge and a misdemeanor charge at the same time, are they consolidated for the purpose of the one bad night rule, or are they only consolidated if you have multiple charges of the same type?
That is a great question that I do not know the answer to off the top of my head. Do you know, Kamal?
And I don't know it either. One of our interns asked me the same question, and I don't know it either. I know that the one bad night provision is also used in the juvenile expungement statute. And maybe there's case law as it relates to how it was applied under the juvenile expungement statute that might be relevant here, but that's a good question. I really
It sounds like a very good research project for a young lawyer or for a law student.
Yeah. All right, so back to the current slide. Deferred and dismissed, I think we touched on this a couple of slides or several slides ago, as far as how they impact the your expungement, the expungement process in general. They will count as misdemeanors for expungement purposes. These were pretty impactful, or they currently are pretty impactful under the current law, because you may have a situation where you think that you have a client has 1 felony, 2 misdemeanors, and it shows up on the iChat, and then they don't tell you about a 7411 or a HIDA conviction. And so you apply thinking that they have 1 felony, 2 misdemeanors, and you find out that they have an extra HIDA conviction, which gives them 1 felony, 3 misdemeanors, and makes them ineligible. So it's still going to be important under the current law, but I don't think it will be as they won't be penalized as much.
Right, because you can
for
have
not knowing or not,
numerous misdemeanors. Mm-hmm.
Right.
Mm-hmm.
Yeah, convictions that were the result of human trafficking, right? They still have so that's something we've never really touched on over the 5 years that I've been with the clinic. We've never had a there's a victim of human trafficking provision, which under the current law allows that person to theoretically expunge multiple solicitation offenses if you can prove that the solicitation was a direct result of being a victim of human trafficking. So that's another interesting tidbit that obviously hasn't changed with respect to this new law. The denial, so under the current law and under the new law, if you get denied, there's a 3-year wait period until you're eligible to refile, unless the judge gives an earlier date. So sometimes, as Dean Brame touched on, we've gotten denied in the past, and we've asked the judge to waive the 3-year wait period. In some cases, the judge has been willing to waive the 3-year wait period. Some cases they have not. So that's important to note with respect to the actual hearing proceeding, if and when you get in front of a judge.
Absolutely. And you can, sometimes ask for, and the judge will, allow, particularly if it's, an error that's relatively easy to fix, or, they will sometimes, allow you to come in sooner than the 3 years. And then finally, and I think we're just right at an hour. So, one of the nice things about this statute, which I assume will continue going forward, is that when you're filing these petitions, there are scale forms that are available, obviously, to you all, to the prosecutor, to the judges, et cetera. So we have a practice. We teach our students to always go into court with a completed form, make it as easy for the judge as possible, because if possible, it's nice for the client to be able to walk out of the courtroom with a copy of their order, right? Because it can take a few weeks for the MSP to update, the background information that goes out when people do background checks. So in the meantime, we want to have an order in our client's hand in case they need to produce it for whatever reason to show that that particular conviction has been expunged. So we try to go in and fill out the boxes for the judge, et cetera. And lately, as the practice became more common, as the court saw more and more of these petitions, the prosecutor often also comes in, right, with a completed form as well. Is that right, Kamal? Anything else you want to say about that?
I'll just say that these forms will be outdated pretty soon.
Yes.
And Noah and I had a discussion about this. Hopefully, Scale will release the new updated forms pretty soon, so we'll have them available for the event.
Yep. So be on the lookout for that. So Scale, has been a good. So thank you guys for asking questions along the way. And we have come right up to the 1 o'clock hour. Please remember, that this was an overview. And Kamal, can you talk a little bit about the training that will come up in advance of the event, of next month's events?
Before you do that, Kamal, I have one final question. I think you might have answered it, but I just want to make sure. It says, I'm aware that restitution will be taken into consideration for automatic expungement, but how is it treated in an expungement by application, specifically if the restitution is a large amount and the convicted has no means to pay?
Right. And that's an excellent question. It's a question I've had with the prosecutor's office. And and they remain adamant that they would object, at least from the information that has been given to me, is that they would object in a scenario like that. So like for a welfare fraud case, oftentimes the client will owe 30 grand, 30, 40 grand in not child support, but restitution, and there's no likelihood of paying. I will say that under the current law, though, under the new law, there is a provision that basically says that the defendant's restitution obligation will not be impacted if the expungement is granted. And so I think you can make the argument that, look, Judge, Your Honor, by expunging this conviction, obviously it would have no impact on the defendant's ability to pay the money. And in fact, it would put them in a better position to pay off the outstanding funds. So I think that would be a legitimate argument.
Mm-hmm.
And I just, I see Kenny just posted it to everyone. This is there's a Google Doc form where you can sign up to be a volunteer attorney for the upcoming event. So feel free to just click on that form if you're interested in signing up for the event.
Yes.
Thank you.
Like I said, please do. And like I said, with that event and in advance of that event will come, training where you'll be able to get, questions asked and actually maybe walk through a couple of the screening examples. So you'll be ready for the event. So it'll be excellent training. Hopefully you'll be able to actually volunteer at the event, but. Mm-hmm.
Right. Mm-hmm. And Dean Brim, I know you had a question about the training. So assuming you sign up for this event, there will be training. Noah and I just agreed on April 1st at 2 p.m. Okay. That's when the first training will be. And I'm willing to meet with people individually if that doesn't work for them. But if you sign up for the event, then you will get an email telling you when the training will be. And then we can go into more depth about particular issues, reading iChats, etc.
Mm-hmm. So with that, thank you all very much for your time and attention. And thank you, Kamal. Now you see why I, don't go anywhere without Kamal. I hope that you enjoyed the session and that you have a good next session.
All right, thank you, Tracy and Kamal. As Kamal said, if you would like to volunteer at that upcoming event, either click on that link or if you have questions, I'm happy to answer any questions that you have. And now it is 1 o'clock, so we're going to jump right back in or right into the next topic. To provide some basics on probate law will be Tim Wakas. He joined the firm of the Svor Wakas PC in 2004 after honing his litigation skills at 2 medical malpractice firms in the Lansing, Michigan area. Tim now practices in the areas of estate planning, probate administration, trust administration, and probate litigation. He is also an active pro bono volunteer with Legal Aid of Western Michigan. Tim grew up in Grand Rapids and graduated from Calvin College in 1996. He received his law degree from Wayne State Law School in 1999. He is a member of the State Bar of Michigan, the Grand Rapids Bar Association, the National Committee on Planned Giving, and the West Michigan Estate Planning Council, and is certified in the areas of probate and estate planning. He was appointed as the Kent County Public Administrator on June 18th of 2020, a role in which he is responsible for decedent estates where there are no heirs or unknown heirs and no last will and testament. With that said, take it away, Tim.
Thank you, Noah. I appreciate it very much. Hi, folks. Hopefully, hopefully this will be a helpful time period for you. I'm going to talk a little bit about probate work and I'll tell a few stories, hopefully. I'm going to assume everyone or some folks will have questions at times. Feel free to ask those. It sounds like I caught the tail end there of the prior presentation, and it sounds like you were asking them as you go. So please feel free to do that as we go through. I don't mind being interrupted with questions. I think it's going to be much more interesting for everyone because I could talk for hours about probate work, but it's not very exciting, I'm sure, unless you get lucky and you have some exciting experiences. But some of it is not very exciting. We don't necessarily go to law school to become an estate planning or probate attorney. I went because I always wanted to be a litigator until I kind of realized what that involved and decided to move on to something else. So if you know what I mean, you understand what I'm saying. One thing I do want to just mention also is that I want to put a plug in for pro bono work and encourage everyone to try to do that if possible. I definitely try to take at least one a year, and in fact have committed to take more than one a year many times, just because I'm trying to help people. That's really why I went into the legal work. And I wasn't smart enough to be a doctor, so I went into the law. Anyway, let me talk a little about probate here. And in particular, when I'm talking about probate today, at least, it's primarily going to be related to a decedent's estate, where someone has passed away and someone has to either get a will admitted or get a personal representative appointed without a will and administer assets. There's other aspects of probate, including guardianships and conservatorships, trust proceedings, and those have some similarities to a probate estate, and I can touch on those, and I'm happy to do that. But for now, I'll just focus on kind of probate estates in this today, at least. One thing I should also mention, I'm sort of, I don't use this term very often, but every now and then I'll say I'm a probate nerd. And that's probably because I have this Estates and Protected Individuals Code, and you can see all these tabs, and it's dog-eared. That gets a lot of work in my office because I have it all in one place. I have all of the probate code in one place. I can refer to it when needed and keep tabs on certain parts that I want to go back to, like the priority of who can be a personal representative. I have that tab right there with a couple notes on who's on there first. And so I can get back to that. But it gets a lot of use, even though I prefer using ICL online, and I'm a member of ICL, the membership that they have. It's a lot easier to just have it right next to me and be able to refer to it. So in terms of probate work, I believe that that is a growth area. It is growing in Kent County. I want to say Kent County is one of the busiest probate courts in the state. I think per capita, based on population, it is the busiest, from my understanding, and it just seems to be growing. Probate work is also a natural outgrowth of any estate planning or wills that you might do. And so if you're a young attorney and thinking about that, that is definitely a positive. You know, you do a will for someone, not hoping that they'll pass away, but if they do, it's natural for the family to come back to you and ask you to assist with the probate work. I have found it to be very rewarding. I've enjoyed it quite a bit. As Noah mentioned, I started out in litigation, doing medical malpractice defense, which I liked. But this is much more of a personal contact with people. You get personal contact with the clients or family members, and you can help them navigate a strange process that is probate, which is really court, and it can be very rewarding. I have very much enjoyed that. So as I said, probate, as I'm sort of talking about today, we're talking about opening a probate estate for a decedent who has passed away. And that's not everyone who passes away. I'll make that point. If after you practice for a while, you'll realize we don't have to open probate estates for everyone that dies. Sometimes persons will utilize beneficiary designations or maybe a trust. And if it's properly funded, they can avoid probate completely. There's no need for opening probate proceedings. But if you have a will and you, or the decedent, I should say, if the decedent passes away with an asset in her name alone or his name alone, then we have to open probate to transfer that. There's no one else authorized to handle that asset anymore now that that person has died. If they had signed a financial power of attorney, those cease at the death of the person having signed it, and therefore no one's authorized. We're looking at, all right, we're going to get these assets transferred. Also, I should point out a will, a person's last will and testament requires something more than just you showing it to someone. Uh-oh. Am I still on?
Yeah, you're good.
Okay. My screen just went blank. Apologize. A will requires something more than just showing it to someone. It requires filing in probate, and it requires someone to be appointed as the administrator or personal representative, formerly called personal representative. I call him a PR. Used to be an executor. So I'll give you an example. I've had clients say to me, well, I have dad's will. He just died. I showed it to the bank. They won't let me handle his account. They won't let me access it. What do I do? How do I pay for stuff? How do I pay for the funeral? And the answer is, we're gonna have to open probate. You're gonna file the will with the necessary probate pleadings and appoint a personal representative who then will be authorized to go in and handle the assets. And what they will, when you get probate open, that personal representative will take a document from the court called letters of authority. Sometimes, I've had this with banks, they'll tell me, well, we need letters of testamentary or something like that. And what they're really saying is we need someone appointed as a personal representative, and they need to be appointed by the court, and then with certified letters of authority, someone can handle the asset according to the rules of probate. So we need to open a probate estate. Our hypothetical client, let's say, says, I have this will, we got to open probate. How do we do that? And that involves obviously the pleadings, like I mentioned. And then there's two ways to open a probate estate. One is formally or a formal hearing, and the other one is informal. And when I first started, I really didn't understand why you would do one versus the other. But having practiced for a while, I figured out that you certainly want to start with, let's do an informal probate. Let's open informally if we can, and if it makes sense, because it's much quicker, much more efficient. You get a client appointed much quicker, and they get their letters of authority, and they can start handling assets. So if you can do that, that's what you want to do for sure. And that just means when they talk about informally, that just means you have not had a formal hearing to appoint that person. And a formal opening of probate simply means you have a hearing to appoint them to go forward. Now, a little history lesson, and I only know this because I've looked at files from the mid 50s and 60s at the probate court, back when you could go to probate court and look at files before COVID. And generally, you had to have a hearing to do almost anything on a probate estate back then. You had to have a hearing, give notice to the interested parties to start the probate. You had to do the same thing with respect to wanting to sell real estate. You had to do the same thing when you were ready to distribute. You had to get full approval and notice it out to everybody. We've had a pendulum swing on that. And if you're practicing in probate now, sometimes you may never have a hearing on a regular probate estate. Everything is done outside of a formal hearing, basically. And that's great because it's less costly to clients, and they like that. It can be a place for abuse, of course, as you can imagine. And that's a discussion that I generally have with the personal representative when they're appointed, which is that's not your money to play with or loan to yourself. You're a fiduciary, et cetera, et cetera. So back to opening it up. Are we going to do informal or formal? Generally, I'm going to go with informal if I have an original will, an ink signed, original will, and I don't see any issues going on. There's nobody who's going to object. There are no children cut out by the will, anything like that. We're just in that situation. I would do an informal filing and go for it and get going. That's much easier, much quicker. There are certain circumstances where you'll balance the efficiency of getting appointed with the benefit of a hearing, of a formal hearing, and getting a personal representative appointed. And one would be, for example, if the will cuts out someone who would rightfully be entitled under intestacy, like one of the children or something like that. that could be a reason to do a formal filing and get someone appointed, because then you have an order of the court that says it's a valid will at the time you open probate, and that can cut off someone from challenging the will. So that's one reason for doing a formal, even though you wouldn't have to. Other times it is required, and one of the times I run into this fairly often is we can't find the original will. There's a copy either in the drafting attorney's file, like I would have, where I keep a copy and give them the original, or someone in the family has a copy, but no one has the actual signed will. You got to have a hearing at that point to get it admitted, and you'll need a witness, one of the family members typically, who can say that they believe that's the original will or a copy of it, for a variety of reasons, including he always said it was equal shares to the kid, and never told me he shredded it or something. That's the type of person or testimony, I should say, that you're going to want in that situation to get a copy of a will admitted. All right. I'm just looking at my notes to see if
I do have one quick question.
For sure.
I think you answered it, but I just want to make sure. The question is, after the application to open a probate is submitted, is a hearing request required, or will the court review the application and approve the personal representative without a hearing?
Sure, that's a good question. Normally, when you file an application to appoint and start probate, it will just get processed, and there will be no hearing scheduled, ordered, requested, or anything from the court. They'll just issue letters and send them back to you. That's normally what happens. Sometimes we will file an application, and surprisingly, we'll make a mistake on there and attach a copy and forget that we have to have a hearing. I've done that once or twice. The court will call me and say, you need to file a petition and have a hearing. So then you do the other filing and you pull it up for a hearing. But generally, the court's going to call and say, you've got an issue here, you're going to have a hearing, and it'll be a petition or whatever. Otherwise, it just gets processed. And interestingly, it's really an ex parte request, that application. After appointment, the personal representative is charged with having to send the filings and especially the letters of authority to the interested parties at that point. You don't even have to give it to them ahead of time. And that's the idea that this is an original last will and testament. And therefore, if that's what you're relying on, the theory is at least, well, then it must be okay unless someone's going to come back and have a problem, because they could always do that. Other issues that you might run into in probate fairly often are no contest clauses. I just thought I would mention those briefly. They are allowed to be used. One can put those into their estate plan documents, whether it's a trust or a will, but they are limited by the statute in Michigan to the extent that such a clause can be ignored if the challenger has reasonable cause. And the classic example, not even talking about reasonable cause, classic example would be one child unduly influences their parent to execute a will to cut out the other kids and give it all to the one. And they include a no contest clause. Now, let's assume that there is plenty of proof that there was undue influence, and all of those issues can be proven. Obviously, the no contest clause is not going to stop that type of a challenge. In terms of reasonable cause, clearly, I mean, if someone were to win an undue influence charge or claim, that's going to be beyond a reasonable cause, and they're not going to have an issue with that clause. But the courts in general, the case law at least indicates that reasonable cause is fairly, what should we say? They're pretty liberal in determining what reasonable cause is. So it's not all that difficult to get past that. In spite of clients wanting them fairly often, I always make sure to mention to them that they don't eliminate every challenge, but they do sometimes cause other persons to debate a challenge and decide not to, which is probably the best benefit you're going to get out of those. As I said early on, a will requires probate to do anything. And as part of probate, there are two groups of individuals that are going to get notified in a probate estate. One would be the heirs of the decedent, and the other group would be devisees, which is persons who are receiving something under the will. And usually, or I shouldn't say usually, but fairly often that is the same. Those groups are the same. But obviously there are times when they are not. So for example, you could have an easy case of, again, the parent who doesn't want a child to get anything. And that child is an heir in spite of whatever they might say about their parent or the parent about them while alive. They're still an heir and they will be notified of the probate estate, even though they're not getting anything as a devisee under the will. And so that's a planning opportunity to discuss with clients, which I often do. And one of the things they can do in that situation is to do a revocable trust, which would avoid probate if it's properly funded, and only requires notification to those who are going to get assets from the trust, which would be everyone other than the one child that they don't want to get anything. So that can be a good opportunity to do some extra planning for the client, but also to lead to a situation where you don't have to tell someone who's not getting anything about the trust and the administration, which can be a real benefit. It keeps them in the dark and keeps them from opening up a can of worms potentially.
While you're talking about trusts, there is a question that came in
You bet.
A couple minutes ago, just asking if the procedures you were talking about for opening an estate are different if there is a trust.
Yes and no. Yes, they're different if there is a trust that's fully funded. And by fully funded, I mean there's nothing left in the decedent's name that needs probate. If we don't have to do probate, the procedures are going to be basically, well, the procedure for the trustee to start acting is without any probate court involvement. So they don't have to the trustee doesn't have to do anything with probate court. They typically would have to do a certificate of trust that we as the attorney would draft for them, and produce a death certificate, which gets issued obviously, and collect assets after that. Sometimes this happens, fairly often, unfortunately. I have clients who have most of their assets in the trust, but did not put all their assets in the trust, and they leave, say, a bank account out of the trust. And that's when you're going to do a probate for that one bank account that's in their name solely, and have to file the will and get a personal representative appointed, all that same procedure. And then as trustee, the trustee will collect the other assets in the trust and take care of distributing. That assumes there's a pour over will into the trust, which if the drafter did their job, there will be. But if the client used an online service, there might not be. I've had that a few times. But yes, generally the procedure to start is a little bit different with a trust, but sometimes you do have to do a probate with it. I should also point out that you don't have to open a probate estate. And as I said, if there's an asset, and that's just assets, in the decedent's name, that's when you will typically want to open a probate estate because you want to gain that asset, or whoever is entitled to it wants to gain that asset. But if you already know that claims against that estate are in excess of whatever the asset is worth or assets are worth, you don't have to open a probate estate. If the debts that the decedent died with, are way more than what they have in the bank and that's all they have, you don't have to open it because it's all just going to go to that creditor eventually. Additionally, if someone doesn't want an asset, maybe it's environmentally in bad shape or what have you, real estate, they don't have to open the probate estate to get that asset. But if they want it, that's the only way you're going to be able to do it if it's left in one person's name after they die. Go ahead, Noah. Did you have a?
There is another question. I think it's a good time to ask this one. In the case of a very small estate, is there a way to pass assets via an affidavit rather than utilizing probate?
Very good question. And that does happen quite often, that it's a smaller, say, bank account. Yes, there are two procedures to utilize to transfer a smaller asset or assets in a decedent's name. One is an affidavit procedure where the signer certifies that it's a small estate and it should be transferred to them or to the heirs, and you have to list the heirs on there. And that can be used. It's not what you'll find is you have to find out what the entity that holds the asset is willing to accept. It's fairly rare that a bank will accept that because they want an order of the probate court or of a court rather than just an affidavit. They're worried someone else is going to come by and claim that they're an heir and they didn't get their share and the bank's got to pay twice. So an affidavit is legitimate under the statute, but not always accepted. The other way is almost always accepted, and that is a small, I call it a small probate petition. Most people will call it that. It's technically, I believe, called a petition in order for assignment. And what that says is the only assets in the decedent's name alone are whatever you've got, and the amount that they are worth is no more than, I believe it's $23,000 right now. At least it was last year. I don't think it changed this year. So they are no larger than $23,000 after the funeral bill is taken into account, after you subtract the funeral bill. The net number after that is no more than $23,000. Then the court will entertain and enter, I should say, that order for you, indicating they can be distributed, that asset can be distributed to the heirs of the decedent. And that's very handy because it's just it's 2 pages in terms of a petition. You file it, the court will issue it, you get it back, and let's say it's a bank account at Fifth Third, you go into Fifth Third and they will split it into 3 checks and either mail them for you, or whoever goes to the bank gets to mail them to the recipients if there's 3 kids, for example. So that works really nicely for taking care of those smaller assets that are not in the trust at their death. One of the things with that small probate petition that is a little frustrating is the statute says that in that situation, the asset gets distributed to the heirs, not to whoever the devisee or devisees are in the will. So if you have a trust and it's a pour over will, the statute says for the small probate petition, well, that's going to go to the heirs. So if you have a trust that says, hold it in trust for my kids until they're 65, they're going to get that asset right at that time. So that's a little bit unfortunate, but that's the way they drafted it. So it is what it is, right? We can't change that. Once a personal representative gets appointed, what's their job? That's a big question, of course. And in general, as a very brief overview, they are charged with marshaling all the assets in the estate, inventorying them and valuing them, and then generally liquidating them, getting tax returns filed, including decedent's final returns, paying taxes, debts, expenses, any claims of the estate, and eventually they get to distribute to the devisees under the will or to the heirs if it's intestate without a will. So in general, that's what they get to do. Lots of different things involved in that. And one of them is the tax returns. For example, if decedent hasn't filed for a couple of years, that personal rep has the wonderful opportunity to try to recreate those taxes and what happened and get those filed. And that can be a big hassle, shall we say. But usually, they didn't file because they didn't have enough income, which is then not a problem. And that can be cleaned up without a problem. But as personal representative then, doing that job, what are the powers that the personal rep has? What can the PR do and how can they do it? And statute in EPIC sets that out. It's pretty extensive. It says a lot of different things. They have a lot of power. They basically have power over everything in the probate estate, and all of it is towards marshaling, valuing, inventorying, and eventually distributing. And so I was talking about hearings before, and as I said, many decades ago, long before I was even alive, you had to have a hearing to do just about everything, including sell the real estate or probably to do almost anything on the estate, as I understand it. So what do you need a hearing for now? Well, generally, you don't need a hearing for almost anything. A general personal representative can do almost everything without having a hearing. You go and have a hearing, you go to court. If there's an issue, if an issue comes up where there's a dispute, or potentially you need, as PR, you need the approval of the court for some reason. And so here are the reasons you would have to go to court. You need to have a hearing because you need approval according to the statute. One classic example is where a personal rep has a claim that accrued prior to the death of the decedent. For example, the client who's the PR, his father died, and his father owed him $10,000. That predated the death of dad, and to get that paid, he's got to have a hearing for approval from the court. Something like that. Or I have another one that's, in fact, in the office right now that I'm dealing with. The personal representative co-owned as a tenant in common a house, but she paid all of the bills for the last 10 years on the house, and the decedent didn't pay any. And under the law, co-owners like that, tenants in common 50-50, are liable for half of all the bills. Each of them are. And he hasn't paid anything, and now he's dead, and she's the PR of that estate. We're going to have a hearing to get approval to pay that claim because she's the PR and there's that conflict of interest. So if there's a dispute, for example, or like that situation where you need approval of the court by the statute, that would be a reason to go to court. Another classic one would be where the personal representative wants to purchase a property or something else from the estate, and not all of the interested parties will approve that, will agree that she can do that. For example, the house on the lake. I've had this situation where the personal representative wanted to purchase the house on Lake Michigan. We ordered an appraisal to get fair market value. She offered that exact amount minus what her share was, of course, so everyone would be made whole. But her sister was very upset with her and just wouldn't sign the paper. So we had to file a petition for approval of that, even though she didn't have an objection, a real valid objection. She just objected because she wanted to. And without everyone approving it, my client, the PR, had to have court approval according to the statute. So we did. Now, is there a question there? No, I wasn't sure. Okay. One of the main things that a personal rep gets to do is pay claims on the estate. When they get appointed, they publish a notice to unknown creditors. They are supposed to also send a notice to known creditors. For example, if you know of, say, the Visa card that mom always used and had forever, you have to send a notice to known creditors to Visa on that. And then those entities will file their claims and or send them to you as the attorney for personal representative. And when you get to the point of having liquidated assets, etc., you know you have enough there to pay claims, you get to start paying claims. And you can do that without a court order. Again, you don't need a court order to pay them. You would, excuse me, you would need a court order if you dispute it, but that falls on the claimant. If you disallow, the procedure is to disallow a claim if it is not a valid claim or you don't believe it's valid. And then it's on the claimant to file a lawsuit in probate court against the estate to obtain the right to payment. So that's on the claimant, and many times they do not file. If you disallow something, they will not file. And that's not to say that you should disallow a valid claim, but if you do disallow a claim that you don't believe is valid, it's unlikely that they'll file. I have found, in my experience at least, they don't file very often on those.
I did have a question.
For sure.
That related to a notice to creditors. Do you have to do a notice to creditors and wait before you distribute to heirs in a small estate?
This is a small probate estate, I assume, right?
I believe so, yes.
Where we do the small probate petition. No, you do not publish in that situation. The publication is done when a personal representative is appointed, not in that small probate petition, because there is no PR appointed in that situation. The statute does say, however, that the recipients of those funds under the small probate petition are liable for debts or claims that would have gone against an estate for, I think it's 63 days after decedent's death or something like that. So there is some liability in terms of having to pay legitimate claims against the estate that would have been against the estate. But generally, there's no publication notice at all. You do not have to do it. And speaking of the publication notice, the statute specifically says if a decedent at the time you open the estate has been dead, for 3 years or more, you do not have to publish. And every now and then, actually more than now and then, I have a few right now, I will have an estate that gets opened more than 3 years after someone passed away, so we don't have to publish a notice to creditors at all. I think the assumption there, although I don't know, is they've already written those claims off, the credit card debt's gone, nobody's worried about it, and so you don't have to file, or you don't have to publish in that situation. I'll wait for Noah for a sec. Doesn't look like it. Oh, okay, yep.
So I have two questions.
That's fine.
This one kind of relates to that, which is how often do you actually see creditors respond to published notices?
Mm-hmm. I see that more often than you would expect. If there is a credit card out there, the creditors, at least as far as I can tell, have someone who scours the Grand Rapids Legal News and the other newspapers that you might publish in for those publication notices. And I see them quite often come in, even though we didn't know about them. So they have figured out how this works and generally are keeping an eye on it. At least that's my experience. Was there another one? Yeah.
Yep, there's one more. This is kind of going back to the transferring of property. If the personal representative inherits the real property as spouse, although the decedent's name was the only one on the deed, can she submit a deed transferring the property into her name as personal representative? And is a hearing required in that situation?
Gotcha. Yeah. Let me think a sec. I don't believe there's any hearing required in that situation because it's basically the inheritance is all going to the spouse for whatever reason. Either it's smaller than her share would have been, or she's the only heir because there's no children at all, what have you. But if she's entitled to all of it, then she can submit a deed. She can sign a deed as personal representative over to herself. If you get title insurance for that transfer, which I would recommend at least checking into, I always recommend it to the client. They don't always want to pay for it, but quite often the title company will want some explanation why she's entitled to that property. And so I will often put in the deed, if there's a specific distribution of the property in the will, for example, to the spouse or to someone, I will say pursuant to paragraph room number 5D or whatever, and put that in the deed so that if there's a question later on, everyone can understand there was a specific distribution to the spouse. But there's no hearing required for that, typically.
All right, we do have one more question.
Of course.
Came in. Who does a creditor sue if there is no estate and PR appointed?
The creditor has to sue the PR well, that's really the estate. So if there isn't one appointed, they have to get one appointed if they want to sue on the debt or on the claim. And as a creditor, it is 42, I'm looking at my sticky note on the Epic book I was telling you about. 42 days after death, a creditor can nominate a personal representative. So 42 days after someone dies, if there's no probate estate open, creditor can nominate someone to act as personal representative. So they have someone to sue in that circumstance. But to file suit against anyone who is dead, it's really the estate care of the personal representative. And along those same lines, every I shouldn't say every year, all the time, not every day necessarily, I get calls from creditors of a variety of different types who want to open a probate estate and need someone appointed. They usually want someone independent on the estate. And then basically they get to sue me as personal representative on the estate. So I have had that a number of times. One time it was a motor vehicle accident and the decedent had died for other reasons and they needed to file a lawsuit. So I got appointed on that. Or it could be a situation where a creditor has a significant claim against a decedent and no one's opened the estate and we want to figure out if there are any assets to pay that claim and investigate where the assets went, maybe. Those types of situations. So you got to the creditor can get a PR appointed in that circumstance, and that's pretty regular. The notice would still go to the interested parties, which is heirs and devisees, and sometimes they'll object to, the creditor appointing someone, but frankly, most of the time the family doesn't even want to deal with it. They know the claims out there and they don't want to be the ones who have to deal with it. So they're fine with someone like me or someone else, independent of everything getting appointed. I'll move on then. So we, in our hypothetical personal representative, and interrupt me if you need to, Noah, that's fine. We have someone and they have paid claims. They have gone through everything. They did the inventory. They've gotten to the point that they're ready to do a distribution. Now, and I should mention too, as a personal representative, sometimes you'll have an estate that has plenty of assets to pay any potential claims and any expenses related to administration and everything else, to the point where you could do a distribution even before the 4-month period for creditors has gone by. And in that situation, if the personal representative wants to, they can make an early distribution, not of everything, because they're still going to have to pay bills as things go on. There might be some more claims, but they can do a partial distribution early on, whenever they are confident they have plenty of assets. And that's an ongoing decision that you can make based on, carrying costs for real estate is the big one. How much I'm going to have to pay for the utilities, et cetera. But once you sell the one piece of real estate, you're in a position where you can definitely do a distribution, as an example. So now I'm talking about, we're at a point where we're to the end of the estate. It's all liquidated. There's a chunk of cash sitting in a bank account under the estate's name, controlled by the personal rep. And what do we do now? We want to distribute everything. And what do we do? My typical procedure is I should back up. The law requires a personal representative to do a final accounting at that point. And technically they have to do an annual accounting every year to the heirs or interested parties, devisees. Typically, most probate estates, you have gotten to the point of ready for distribution within a year of appointment. Not always, but fairly often. So you only have to do one final accounting. Otherwise, you're supposed to do an annual one every year and explain where things are at. But then we get to the point of a final accounting. I normally have the client put that together if they've been keeping track of things as they've gone along. It's not too hard to do then. And I have them bring it to me. We go over it and I make sure it makes sense. There's nothing that jumps out at me like a $10,000 payment to some unknown entity or something like that. Assuming it's in good order, I will generally then send it to the interested parties who are going to, or the devisees, I should say, who's going to receive assets. And I will give them usually a receipt to sign and an approval document where they say, I've looked at this accounting and I approve of it. And once they sign that, then the personal representative can make their final distribution. And that's all outlined in that final accounting, how much they all can expect to receive. As part of that, I will also hold back or have an indication in there of what my final fees will be and anything else that we're holding back for, so that we've got a little bit of a cushion there if there's more work or more questions. And assuming they approve it, we might give them even more if there is less work that we have to do. No one complains when you give them more than what you told them you were going to, so that's usually not a problem. Sometimes we'll get an objection, or someone will refuse to sign the receipt and approval. And in that circumstance, we normally then file in the probate court for approval of it. And they either come forward with their objections and explain why they are objecting, or the court's going to approve it. And if they object, then we deal with them and try to get the court's approval the way we want it, or the judge decides. But that's another reason we might wind up in court. Again, this is all supposed to go through in a normal circumstance where nobody's fighting. But if people want to fight, then you will wind up in probate court on these, for sure.
I do have a question.
Yep, great.
Pausing. Can there be an account of a trust if one spouse is still alive and no distributions can be given until other spouse dies?
I think the question is, do you have to do an annual accounting even though you don't have to do distributions to the spouse who is surviving, it sounds like. And maybe that spouse is the trustee of that trust, would be maybe what's going on. Generally, even if you say there are no accountings necessary, a court could order accountings. If the spouse is the trustee and the sole current beneficiary, they really do not have to do accountings to themselves, wearing one hat, versus the other one, being trustee versus beneficiary. That's obviously within their knowledge, and they don't have to do a formal accounting. And generally, those formal accountings don't have to go to the next set of beneficiaries, which I usually call contingent beneficiaries. But there are circumstances where a court can order that, and the trustee might be required, I should say, to do that. So it is possible. Generally, most trusts in that circumstance are not going to require accountings to the contingent beneficiaries, however. Is there another question? No, otherwise I can keep running here. Okay. One fun thing about probate is you can touch on a lot of different areas of the law. Real estate, you always see that, and sometimes it's as simple as helping do a buy-sell for the estate or the personal representative to sell the family home or whatever. They find a buyer on their own without listing it, and you make sure they get an appraisal so that they have a good value in terms of obtaining that sale. But then you draft a buy-sell for them. You call the title company and get title work, and you help, as I tell them, I shepherd you through closing. It's not hard to do. It's kind of fun. And they're saving a real estate commission, which they kind of like, obviously. So as long as they get a good value, as long as they get fair market value, and that's why I require them then to get an appraisal, so we're confident, that's perfectly fine to sell it without a realtor. It's a lot easier, however, to just get a realtor to tell you the market analysis and let the market take it. Right now, everybody, if you're looking at real estate or even feel like thinking about it, you'll know the market is extremely hot. And if you want to get your best value, I always tell them, just get a realtor to list it. Because right now, I have sold 3 properties that I was shocked at how much they sold for, 2 of which were 20 to 30,000 over list, and 1 of which didn't get list, but still sold for way more than one would have thought. They were in bad shape. So but that's kind of fun that you can do some real estate somewhat, you get across the line into real estate a little bit. Sometimes there's an issue on the title to real estate in a probate estate, and you have to resolve that or figure that out. Or sometimes you'll have a decedent who owns commercial property, and you want to sell that, and you may find out, well, it would be best to do an environmental assessment of that. All of a sudden you get to learn about environmental law, which I know very little about, but I know some people who I can call to help me with that. Speaking of real estate, you, in a probate estate or even in a trust, you'll run into a decedent who owned fractional interest in a piece of property. I have a client right now who owns a 1/3 interest as tenants in common, which is an inheritable interest as opposed to rights of survivorship. She has a 1/3 interest in a small vacant lot on an island in Lake Superior. And it is probably not worth very much. And neither co-owner wants to buy it. And now we have to decide what to do. We could abandon it, and I probably would petition the court for approval of that, just because I don't want someone to claim it's worth $1 million and look, how could I waste that money? Or the other option is to start a partition action against the co-owners and request the court to order it be sold. Or I guess we could try to sell it, but no one's going to want a third interest in a little vacant lot on an island in Lake Superior. Maybe on a warm summer day, but that would be about it. But that is an issue, and we're going to have to figure this out. I'm talking with the client. In fact, right now we've been talking about this, and we're hoping one of the other heirs is going to be willing to buy it. So that's also an option. Again, this is like, okay, are we going to file a partition action, which has its own issues with it and is very interesting, but you run into these things sometimes, and it can be very interesting if you like to do different things every day. That's what probate can be like. Or in fact, I run into this fairly often. Thank goodness it's not all the time. I run into situations where I'm spilling over to criminal law. And that is, for example, conservator who is no longer conservator, but a former conservator calls me and says, I need your help. They're claiming that I stole money and I didn't steal any. And the first thing I say is, well, if you have the police calling you, well, let's get a criminal lawyer involved, and he or she can certainly advise you on the criminal side. I can help you with the probate and the civil side, and we can get this resolved. But that happens, for example, or where I represent the new conservator, and she discovers that the prior conservator stole money from the ward. Again, that's something that I would more than likely get the police involved with and try to, if I believe that's what happened, try to get that person charged. And then we would also pursue them in the probate court for an order to return the funds, etc. So always very interesting to do that type of thing. You get into a lot of different things. But I will just put that final plug in for probate as a very fun situation, even though in law school, I wanted to be a litigator. Everybody was going to be a litigator. Actually, probate can be somewhat fun in that fashion. So that is really my presentation. I hope there's more questions, because you guys have great questions. I like those. But and I probably put everybody to sleep, so I apologize for that too.
Well, yeah, please. There are no current questions, but feel free to ask more. I do have one question that I will
Sure.
ask you that we see here at Legal Aid sometimes. So if there is a home that an heir is living in, there is an estate going on regarding that piece of property, and the heir, it hasn't been decided what's going to happen with that piece of property, but the heir is getting eviction notices. Kind of where in the process does that typically happen with a PR trying to evict people from the home prior to it being determined who actually is getting it or what's going to happen with it?
Mm-hmm. Mm-hmm. Normally that is going to occur where the PR is saying, we've got to figure out what to do. I've decided it needs to be sold, really, I think. And more than likely, this person living in the home is not paying rent towards the property. And that's a good point. I'm glad you brought that up, Noah. In a probate estate, and this is also true in a conservatorship, for example, if a person, normally family member, of course, is living in the home that is a part of the estate or the conservatorship, they are, or I should say the fiduciary, the PR or the conservator, is required to charge rent of them. And that's because they are exclusively using someone else's property to the detriment of the person who's entitled to it, persons entitled to it. Even if they're an heir, unless they're the sole heir, they're using it and others are not, they should pay rent for that. And that's true in a conservatorship, for example, where a mother is in a nursing home and a child lives in the property, they should pay rent. And the court always makes that point to fiduciaries, and that's what the law says. So in that situation, you're probably, especially it's coming to you through or at legal aid, right? I'm going to assume the heir doesn't have the funds to pay rent, probably. And the PR is saying, well, if you're not going to pay rent and you're not going to be able to afford the house, then I have to liquidate it and I need you to leave. And then, of course, they won't leave, right? Those are tricky situations because that's probably what's happening. The PR has a duty to liquidate and maximize the value of the estate for all of the beneficiaries or heirs. And that's including the person living there, but also others. Sometimes it's just out of malice that they're doing that because there's other issues going on as well. But those are kind of tricky. That's exactly right. But that's usually what's happening. It's kind of like, you're not paying rent and I do have to sell it. You may buy it. Oh, you can't afford it. Okay, well, then we got to go to the next step.
Yeah. And as a follow-up, someone asked which court would have jurisdiction to evict that individual.
Very good question. The probate court has exclusive jurisdiction with respect to everything about a probate estate, among other things. I mean, with trusts, etc. And if you review the jurisdiction, the exclusive jurisdiction statute, I believe that the probate court has jurisdiction over that eviction. However, if you come to this, that's my standpoint as a probate practitioner. If you look at it from landlord and tenant law, if I understand right, and I haven't looked at that very closely, of course, if I understand right, exclusive jurisdiction is in the district court for landlord-tenant cases. So there is a case or two that has talked about this a little bit, but I don't have a real great answer on that. I think that you can go to probate court or district court, either one, landlord-tenant court. You can go to either one and you're allowed to do it either way, I think. Not totally sure on that. That's a very good question, though.
And then I have one last question that came in. If you could comment on invalidation of a will or will revocation, where is the burden of proof?
I'd have to look closely. Well, I should probably research that to give the real perfect answer on that. But generally, I believe that if you're challenging the will, you as the challenger have a burden of proof. You have to prove that the decedent lacked capacity to make decisions and shouldn't assign that will because they didn't have the capacity, or was subject to undue influence, and this really wasn't what she or he wanted. I think that's on the challenger to start. With undue influence, there is a presumption of undue influence, and I thought I knew what that meant, but I think there's a case that's changed that, and what that means if it changes, it's very confusing to me, I should say, on the presumption and if it's burst or not. But basically, it starts with the challenger. I think it falls on the challenger to prove, at least from the initial standpoint, both of those or some other reason in terms of why it should be invalidated. And I do think the case law and the language in the case law on undue influence really make clear that it's a pretty high standard, not that it's higher than, say, a preponderance of the evidence, which I believe it is, but they're not easy cases to prove. That's where the presumption comes in, because if you have a presumption of undue influence for some reason, that's very helpful in proving it. And as I said, I haven't done the research in a while, and the way I understood that presumption, I think, has changed by a more recent case. So it's an interesting area of the law for sure. All right.
All right. Well, I think we're good. So thank you very much for taking the time. I don't think you bored anyone. There were lots of questions, so people were engaged. So thank you very much. I am going to take a short, like 3-minute break until 1 to get started with April. So just hang on and we'll be right back. And thank you again, Tim.
You bet. Thank you, Noah.
Thank you all for staying around for our final speaker today, April Holst. She is a partner at CBH Attorneys and Counselors, where she specializes in bankruptcy, estate planning, probate, and general civil litigation. Prior to joining CBH, April practiced in Chicago for 4 years and managed a local Grand Rapids office for a multi-state bankruptcy firm. She is licensed in both Michigan and Illinois. April is active in the Women Lawyers Association of Michigan for the Western region and has served as the president, vice president, and secretary in the past few years. She is a member of local rules committee for the U.S. Bankruptcy Court for the Western District of Michigan, in Forum, the Federal Bar Association of Western Michigan, and the Debtors Bar of West Michigan. April received her undergraduate degree from Illinois State University and her law degree from Valparaiso University School of Law. So let's welcome April Holst.
Good afternoon, everyone. I hope you're feeling excited to learn a little bit about bankruptcy law. I'm going to start off with a brief summary today, just of the options that are really available for individuals. I'm not going to get into Chapter 11 or Chapter 12 today, otherwise we would be here for a very long time. Then I'm going to take you guys through a typical intake that I would do with a bankruptcy client. And while I'm doing that, I'm going to point out the reason why we ask these questions, some of, and how the answers may impact some of the reasons why, bankruptcy would be a good option or perhaps not. If at any time during this presentation you have a question, please feel free to ask it. I love questions. I prefer to answer them at the time. You can also wait till the end, whatever you prefer. So to get started, there's really two options that individuals have when they're thinking about bankruptcy. There's the Chapter 7 bankruptcy, which is considered more of a liquidation type bankruptcy. You usually get a discharge within a few months of filing it. There's no repayment plan in that type of bankruptcy. However, you do have to be below a certain median income level to qualify. So to give you an example of that, so for a one-person household, it's about $53,000, two-person, $66,000, three, $79,000. It kind of goes up by $9,000 increments for each additional person that you have in your household. A Chapter 13 bankruptcy is more of a reorganization type bankruptcy. It's where you pay back a portion of your debt over a period of 3 to 5 years. And at the end of that 3 to 5 year period, as long as you've made all your payments as you're required to, it will discharge the remainder of the debt. Now, there's a lot of reasons why someone would be in a Chapter 13. One of the biggest reasons is because they can't qualify for a Chapter 7. Maybe they make too much money, or they have assets that they can't protect in a Chapter 7, but they want to keep. They want to strip a second mortgage, they're getting garnished, can't afford to pay for the 7, really need to get immediate relief and do a Chapter 13. We're going to get into that a little bit as I go through this presentation. But I'm going to start with this intake questionnaire, and I'm going to share that with you guys so you can kind of follow along as I'm going through it. And I'll explain kind of why we go through these. So share this. All right. So this is the questionnaire that we give clients. This is usually after the initial phone call. So typically how it starts is someone calls our office, they're interested in filing bankruptcy. In our office, the attorneys handle those initial phone calls. And the reason for that is because usually the person that's calling is really stressed out. Sometimes they're embarrassed. It's a very emotional type of case. And we find that by talking to them directly and then scheduling the appointment with us, they're more likely to come in. So, if you're considering starting off, I kind of recommend you being the person to deal with that initial phone call. And then during that initial call, we usually get some basic information, just so I have an idea of what I'm looking at when this person comes in, and then we'll email them this intake questionnaire, which we go through together when they come in. So, the first question is, have you ever filed bankruptcy? And that's really important because there are time limitations on when you can file bankruptcy again if you filed one previously. So if you filed a Chapter 7, you can't file another Chapter 7 for 8 years. Or you can't file another 13 then for 4 years. If you filed a Chapter 13, you can't file another Chapter 13 for 2 years, or a Chapter 7 for 6 years. So it's kind of a 2, 4, 6, 8 rule on when you can file bankruptcy again. So that's the first question, because you might run into someone who's like, I just filed a Chapter 7 last year. Well, there's really going to be very limited options for that person. And then it might be instead, let's take a look at the other debt relief options that you might have. Maybe we could, look into a debt negotiation, depending on what's going on with their financial situation. Have you ever been divorced? This is important because property settlements can come into play when you have a Chapter 7 or a Chapter 13 bankruptcy. So if they have something that's outstanding from a property settlement, maybe there were some joint debts that one of them was supposed to pay. It's important to know that, because property settlements can't be discharged in a Chapter 7 bankruptcy, but they can in a Chapter 13. So that might be one thing that triggers them to be in a Chapter 13 versus a 7. Have they lived in Michigan for the past 2 years? Depending on that answer is what exemptions we can use. So if they say they just moved here from Florida last year, if they haven't been in Michigan for 2 years, then we have to use the exemptions that Florida law allows, which can either be the federal exemptions or the Florida state exemptions. So again, that's another thing that's important, and that would probably trigger a question of, have you been in this area for the last 91 days? Because where you can file the bankruptcy is where they've lived the greater of the last 180 days. So if they just moved over to Grand Rapids from Detroit, it would be an Eastern District case versus Western District, unless they wanted to wait that additional time period. Are you single or married? That's important for household size. It's also important because some people don't want to file with their spouses. They want to file separately, and that's fine, but we still need to disclose spouse's income. So that's just another conversation to have with somebody, if that's something that they're concerned about. And then as kids, again, this is household size. And the reason that we ask for under 18 and over 18 is because children under 18 are automatically dependents. Over 18, some might be living at home, some might be going to college. Are they really a part of the household? Are they making income? That could affect, what you're paying in a Chapter 13 bankruptcy. So again, just things to keep in mind. For real estate, and just to tell you guys, like when we're going through like a bankruptcy intake, we're really looking at 3 things: assets, income, and debts, because that's really what you're going to have to disclose. And that's what's going to make a difference on like what the options are. So we have to get an overview of everything. And sometimes even after going through this intake and giving them a questionnaire that they fill out and with more detailed information and providing documents, we don't even find out about assets until closer to the time we're going to file. So having a really good intake questionnaire is only going to help you. It's something that you can always refer back to, because you'd be surprised. A lot of clients might say, well, I told you about that and you pulled this out. No, you didn't. We didn't talk about it. So good to try to get as much as you can in the beginning. For real estate, right now, this is like probably one of the assets that is causing the most issues for our clients, because the market is so inflated. It's such a seller's market right now that the value of houses can have a significant impact on a debtor's bankruptcy or their options for bankruptcy. So we need to have an idea of the value. Typically, we would just be able to use the SEV times 2, but now we really need to have people get current market analysis so that we know exactly what that house is worth, what's owed on it, so that we can determine the equity. Because when you file bankruptcy, all of your assets are put into this bankruptcy estate. It's like a pot. And then we take all the assets out with the certain exemptions that we get for each asset. For real estate, there's 2 different exemptions that you can really use in your bankruptcy here in Michigan. The federal exemptions or the Michigan exemptions. So For real estate, if you're married and you own it together, it's about 50,000. So if someone has a property and they have way more equity, then that's a red flag for us. We got to, take a look at that and see, what the options really are for that. And the other thing that we are really looking at when we're asking about real estate is, are you behind on your mortgage? Because if you're behind and you have some arrears, that might be something that a Chapter 13 would be a good option for you, because you can catch up on arrears in a Chapter 13 bankruptcy. Or if you have 2 mortgages and your house is worth less than the first mortgage, in a Chapter 13 bankruptcy, you can strip a second mortgage throughout the plan. Names on the title. A lot of people think just because they're married, they're on the title together. I have found that's not always the case. So knowing exactly how the property is titled is really important too, because sometimes if it's just in husband's name, that means that he's the one who has to be able to exempt all of that equity. And you can't just simply transfer it to wife, because that could appear as a fraudulent transfer. So knowing how it's titled so that we can kind of look at how the exemptions are. And then, the other thing is, are they upside down? And another hard conversation that we have to have with clients who own real estate and are considering bankruptcy or other debt negotiation is, if your home is worth a lot less than you owe, one, how long is it going to take you to even have any equity in the property? Is it worth keeping it? Or if we're going to file a bankruptcy, is now the time to get rid of that burden and find something else? There's also the possibility to look at for a loan modification too. If this is the only thing that is triggering a bankruptcy, maybe because there's a foreclosure pending and you don't want your house to get foreclosed, a loan modification might be a way to get around that too. So some of the things that we look at there. For vehicles, again, looking at value, NADA guide, Kelly Blue Book, amount owed, just to see what kind of equity we have in there. You can exempt 4,000 of equity in one vehicle per person. And we also look at when you purchased it, because if you have a car that's worth less than you owe and you purchased it more than 910 days prior to filing bankruptcy, you can cram down that vehicle to what it's owed in a Chapter 13 bankruptcy. In a Chapter 13, you also can cram down the interest rate. So that could be huge for some people who have, interest rates at 20% or so. And then, are you current? Because if someone is behind on their vehicle and they file a Chapter 7 bankruptcy, it's not going to get you current on that. And if you can't get current on it, it could trigger them repossessing it. So then that might be a reason to go into a Chapter 13 too, just to give you time to catch up on that. We also want to know, is your name on anyone else's real estate, financial accounts, vehicles, anything like that? A lot of people have family members that have put them on bank accounts or real estate for estate planning purposes, and that can cause some issues in a bankruptcy as well. It just depends on the situation. If you guys are sharing bank accounts and putting all kinds of money in there, mainly with real estate is probably the biggest concern. But again, looking at that as, what are your total assets? Does anybody owe you any money for any reason? When you file bankruptcy, you have to list all of your assets and any assets that you may have at that time. So for instance, if you got in a car accident prior to filing, although you haven't filed the personal injury lawsuit yet, that would be an asset in your bankruptcy that you would have to list. And you can exempt a part of it, but probably not all of it. So things to keep in mind. And that kind of goes into, can you sue for any reason, like workers' comp claims, medical malpractice, anything like that. Inheritance. If someone recently passed away prior to you filing bankruptcy and you are set to inherit some money, that's going to be an asset in your bankruptcy. Inheritance is also something that can be still an asset if it's within 6 months of filing your bankruptcy too. So if someone passes away within 6 months of filing bankruptcy and you've inherited a bunch of money, then you're going to have to let the trustee know, and that could be a part of it too. So I guess to keep in mind, if you have a client who has an elderly parent and they're worried about them, then that's a consideration. Hey, do we hold off on filing this bankruptcy to see what's going to happen with this person? Or, you know, definitely protect yourself, make sure you have some sort of CYA about that, so that clients can't come back to you later and say, I didn't know about that. Tax refunds are considered an asset. So if there's back tax refunds that are owed to you, those are something that you have to list. You also have to list prorated tax refunds for the current year. So right now, if I were to file someone's bankruptcy, I would list, you know, like 25% of what they would get for 2021 and exempt it. If we don't do that, the trustee in a Chapter 7 would come back and want that money. In a Chapter 13, tax refunds are looked at a little differently. They're mostly just disposable income. And I'm not going to go into that whole thing, but it's a consideration as far as like what they have the ability to pay. Let's see, I'm going to move down here. And then finally, we're just kind of looking to see what you have in your financial accounts. Retirement accounts are fully protected in a Chapter 7 bankruptcy under the federal exemptions. If you are filing with the Michigan state exemptions, it depends on the type of account, but any payments made within the 120 days, like into a retirement account, may not be protected. So again, with all of this stuff, and you may not know it at the time that you retain somebody, but which exemptions you use is going to determine what's protected and what's not. Transfers. So we ask our clients to disclose any transfers in the last 6 years. In the bankruptcy petition, they're only asking for the last 2 years. However, the Michigan statute of frauds goes back 6 years. So we want to know if there's any like major fraudulent transfers within the 6 years prior to filing, like say you had a piece of real estate and then you deeded it to your mom just because you wanted her to have it, or you know, you were afraid someone was going to take it. That would be considered a fraudulent transfer. And it may not be something that you have to disclose because if it's not in the last 2 years. However, we want to know about it because it could be an issue that comes up. So payments. And you know what, just to touch on this, fraudulent transfers aren't always considered fraudulent to the client. Clearly, you know, but the trustee looks at it a whole nother way. And just to give you an example, in a Chapter 7 bankruptcy, the trustees get paid based on what they bring into the estate for the creditors. They're representing the creditors. And they get a percentage of what they bring in. So they're looking for anything that they can that will, you know, get money to creditors and get money to them. I have had, and as a bankruptcy attorney, this is something I've learned just after meeting with hundreds of people, but you will meet with clients and you will ask them, you know, have you transferred anything in the last 6 years? And then they'll tell you something, and then I'll have to do my spiel like, okay, fraudulent transfer. I know you didn't mean it to be fraudulent, but you didn't get fair market value in return. So if you transfer something and you don't get anything in return for it, or the fair market value of it, that can be considered a fraudulent transfer. I've had clients say to me, well, forget I told you that. Just, you know, let's just forget I said that. No, no, we can't forget that. And I can tell you, like, I haven't retained clients for that very reason. And then I'll see them at bankruptcy court with somebody else who I know they never disclosed this information to. But you got to beware because, you know, when you're signing that bankruptcy petition, you're signing it under penalties of perjury. As the attorney, we sign it as well, you know, saying that we're verifying this is all the information that we're aware of. So no one can, you can't hide anything, you can't forget anything. And again, another good reason to have it in your questionnaire, because if something like this is disclosed, you have to list it in the petition. So payments, we asked this question, have you paid any one creditor more than $600 in the 3 months prior to filing? And the reason that we asked this question is because if you pay, if anybody gets more than $600, just to one single creditor, and we're not talking about secured creditors like cars or mortgages or stuff like that. We're talking about like unsecured debt, like medical, credit card, personal loans, family members, for an antecedent debt, for a debt that's, past owed, not like current continuing debt, it is considered a preference. And the trustee can take that money back from that credit card company, and they split it evenly amongst all your creditors. They're basically saying it's not fair that you paid Chase Bank for this credit card debt and Capital One here didn't get anything. So they'll take it and they'll split it evenly. For relatives, it goes back 1 year. So if you borrowed money from dad and you decide to pay him back, you get your tax refund, you pay him back $2,000, well, that's a preference. And if we don't settle with the trustee in a Chapter 7 bankruptcy, then they're going to pursue dad to get that money back. They would sue dad. But these kind of issues, fraudulent transfers and payments that may be considered a preference, those are things where you might say, wait, you know what? Maybe Chapter 7 isn't a good option. Maybe we do Chapter 13. Because in a Chapter 13, as long as we pay back what they would have gotten in a Chapter 7, we can avoid this. We can avoid dad getting sued. We can avoid a fraudulent transfer action against, mom for deeding a house to her. As long as we, negotiate with the Chapter 13 trustee. And I will say it is a lot easier to negotiate with the Chapter 13 trustee in some of these instances than it is with a Chapter 7 trustee. There's just more room to move. So if a client is really concerned about that and it's a larger amount and they don't have the ability to pay it back to the trustee, we might suggest, let's do the 13 then, and we can pay it back over time. So then we get into our section on debts. So when you file a bankruptcy, you have to list any debts that you have, any and all debts. You can't choose to leave some out. Some people, have favorite doctors or, friends or whatnot that they don't want to list, but you have to list all of your debts. And that's required. If you decide that after you file a bankruptcy that you want to pay somebody back, you can, you just won't be obligated to. Now, not all debts are dischargeable though. So, typically, unsecured debts such as credit card, medical, personal loan, any, debt from like repossessions or foreclosures, those are going to be dischargeable. Student loans are not dischargeable, not yet, but let's keep our eye on that because I feel like that's happening soon. And I don't know if you guys pay attention to some of the acts that Biden has put into place. Maybe like a week or so ago, there was a new act that he passed, which basically said that I believe for the next 3 years, there won't be any tax liability for student loan debt forgiveness. So I think that's kind of setting it up so that if, we are able to discharge student loans in a bankruptcy, or if he's going to just forgive some certain amount of student loans, that there's not going to be any tax liability for it. But I do think that there is going to be something that happens with a Chapter 13 bankruptcy and student loans, in this next year or so. So keep an eye on that. Alimony and child support payments, those are not dischargeable. You're not getting rid of those. Criminal restitution, that's not going away. But there are some types of criminal type fines or fines that could be dischargeable, like a driver's responsibility fee. That is something that could go away that you could get your license back for in a bankruptcy. credit union. We ask about credit union debts because credit unions do something that a lot of people don't realize is they cross-collateralize your debts with any assets that you have. So if you have a bank account with a credit union and you also have a credit card, they secure themselves onto your bank account. And even if you file bankruptcy, they can freeze the account and take the money. So we always want to know about that, because if you have a debt with a credit union and you bank there as well, you probably want to switch your bank before filing. I've had this happen to clients before. It's an awful situation. You have all your money in there and then they freeze your account. It can put you in a really bad situation. So that's why we ask about that. Same thing goes if you have a car with a credit union, they will secure your credit card onto that car too. So even though you're paying both and it doesn't seem like it's on your car loan, it actually is. However, I will say they are pretty good about not tacking it on when you do a reaffirmation. And what a reaffirmation is so when you file the bankruptcy, it discharges your liability to pay everything, except for certain debts that you might want to reaffirm. You're required to reaffirm cars. You don't have to reaffirm mortgages. You just can continue to make the payments. But for vehicles, you have to. So for some credit unions, they would try to tack on that credit card debt onto the loan. And the judges really just didn't like that very much. So we haven't had that issue as much now. But just something to keep in mind, if you're banking with a credit union and you have a large debt with them, probably don't want to use them for a car loan too, or your clients don't. Taxes. So taxes can be dischargeable in a bankruptcy. And whether or not those are dischargeable is going to depend on three things. And this is where having this knowledge can be really, really important, because if you mess something like this up, it could be a really big deal for your clients, because if they had waited maybe just, a few months, this debt may have been dischargeable. So it has to be more than 3 years old, meaning that, right now, 2020, we're kind of like at the 2020, like that's the taxes that we're filing. So 2020, 2019, 2018, those would still be within 3 years. But 2017, if you had tax liability from 2017 and it was filed at least 2 years ago and the debt has not been assessed in the last 240 days, that amount could be dischargeable. Whenever you're looking at whether or not tax liability is going to be dischargeable, you absolutely have to get the tax transcripts. That is the only way to really look to see when debt's been assessed, if there were any, if they were filed late, because otherwise you can rely on what the client says, but that's really going to be the for sure way to know. Because like I said, if you wait a little bit, you could discharge some tax liability, whereas if you file too soon, you might not be able to. And really, like, whether or not they're more than 3 years old is going to depend on like when the filing is due. So that's something else to keep in mind. Other debts that may not be dischargeable would be debts for fraud, debts for a personal injury if you were intoxicated that caused that personal injury. But that's going to depend. Some intentional torts such as contempt, those can be dischargeable, but not in a 7. You'd have to do that in a 13. So there's a bunch of debts that are listed under 11 U.S.C. 523. That's kind of where they list like the debts that are not subject to a discharge. It's not automatic. So if you list a debt for, say, it was a breach of contract and they allege some sort of fraud, that creditor would have to bring something called an adversary proceeding to basically argue that debt shouldn't be discharged. But again, there's something to keep in mind, because depending on the kind of debt they have, and if they have some really aggressive creditors out there, you may want to file them as a Chapter 13. And to give you an example of that, I still have this case where my clients got hit with a pretty large contempt of a preliminary injunction debt. And that is not dischargeable in a Chapter 7 bankruptcy, but intentional torts like that are in a Chapter 13. So, we chose the Chapter 13 for that very reason. And I mean, that's just something to consider, that's why we look at all of the debts and any possibilities. And again, you're not going to always know if a creditor is going to bring an adversary proceeding, but in some instances, you can kind of tell just because of, what's been going on in the state court. Co-signers, that's important because if you have joint debts with somebody, it's going to discharge your liability on the debt. However, they're still going to be on it. And then they get notice of your bankruptcy as well. So we need to list that and we need to list them. Whether or not you have any pending lawsuits, foreclosures, repossessions. We want to know that because one, we want to know, are you currently being garnished? Is there a foreclosure pending? Because if there's a foreclosure pending on your house, we need to file before that foreclosure occurs in a Chapter 13 to prevent it. A Chapter 7 would delay the foreclosure too, but it's not going to delay it long enough for you to get current. So if you really wanted to keep the home and get current on any arrears, you would have to file a Chapter 13 bankruptcy before that short sale happened or that sheriff sale. So knowing those dates is really important in getting those notices from your clients. Repossessions of vehicles. We can get back a vehicle that has been repossessed if we file within a certain period of time beforehand. And I can't remember the exact timeline. I just did one and I don't know why it's escaping me at the moment, but we can get a car back, but you usually have to pay the fee to the storage company in order to do that. And sometimes we'll do a Chapter 13 bankruptcy so that we can pay that over time if they're willing to do it. So we also want to know about businesses.
I do have a question that came in. If someone enters into a consent divorce decree / judgment that specifies that one of the spouses will not discharge certain obligations in bankruptcy, as an example, to protect the other spouse in the case of a joint obligation, is it enforceable?
Well, it depends on which bankruptcy you file. So that's considered a property settlement, and you can discharge a property settlement in a Chapter 13 bankruptcy. So you can basically get rid of that obligation to pay those joint debts. And that happens a lot. And you have very angry spouses in that situation. So, but yeah, it is. And that's one of the considerations that we look at when we're, asking if they've been divorced is for that very reason, because somebody might owe somebody something like in their divorce decree and they can't afford to pay it, or it's not feasible, or there's all these joint debts because one spouse doesn't want to pay or doesn't want to file. The other spouse is stuck with all these, but they can't pay it. That would be a reason to have a Chapter 13 versus a 7. All right. Businesses, any debtor who is a member of a business, operating a business, even as a DBA, we need to disclose those interests. So, if you have an LLC that you're a member of, we disclose what your membership interest is worth. And usually what that is, what assets does the business have, bank accounts, what liabilities, and then we kind of put a number on that, but we disclose all of those as part of the membership interest. If it's a DBA, you're just kind of operating as a sole proprietor. Again, we list all of the assets of the business. Those are, part of your bankruptcy too. Sometimes we'll have clients who have ownership interest in business, but the liabilities exceed the assets, so it's really not worth anything. But in any event, we need all that information, and especially for the business income and expenses too. When we disclose that income, we're disclosing the net income, not the total gross, but after your expenses, the net income is what ends up being disclosed in your bankruptcy. But income is important, as I said, because that's what's going to determine, will you qualify for a Chapter 7 or do you have to be in a Chapter 13 bankruptcy? One of the reasons why we want to know about business income or business debts too, or something that might be personally guaranteed to you, is if you're over the median income level to qualify for a 7, but you have primarily business debts, the means test doesn't matter. Median income doesn't matter. You can file a Chapter 7 still. It's kind of just this loophole that lets you get into a Chapter 7, and it's just because they don't want to punish people who have decided to take a chance on operating a business. So they allow them to kind of get past this one barrier. But if you just have primarily consumer debts, you still do have to meet this median income level requirement. And if you're significantly above that, the likelihood that you would qualify for a Chapter 7 is probably smaller unless you have some significant debts, such as, really large medical debts, not debts, but expenses each month. So that's why we look at that. And when we're looking at that, we're really looking at the 6 months prior to filing. That's what's used in the means test. They basically take that 6-month average and say, okay, this is what you make per year. So in some instances, someone might have just lost their job. And so we would just need to wait a couple months and maybe they would qualify for a Chapter 7. Or someone may be getting a new job, which is going to be making a significant amount more. And maybe then if they really wanted to do a Chapter 7, we could try to do it, but it depends. Like the other thing that goes into play with filing a bankruptcy is this underlying principle of good faith. So, it's for the, it's for the debtor that really wants a fresh start, but, everything has to be proposed in good faith. And if you're making a significant amount of money, even though you just got that job and you might qualify for a Chapter 7 otherwise, they do look at the median income level to see if you qualify for a Chapter 7, but they also look at your budget too. So if you have a lot of extra disposable income left at the end of the month, you probably would get a motion from the U.S. trustee that it's bad faith and they want you to be in a Chapter 13 because you make enough money, you can afford to pay something back to your creditors. So that's another thing to keep in mind is with income, it's not just simply, oh, okay, here's what we make, we qualify. They're looking at the budget as well. And for income, when it comes to spouses, if your spouse is non-filing, that can affect, your budget too. So non-filing spouse isn't required to pay the debts of their spouse. So we can usually take out a lot of their income, or they can use a lot of their income for their expenses or other things that the trustee may not think are exactly reasonable, just because they're not filing the bankruptcy. But in any event, all income has to be disclosed. Social Security, pension, if you recently, won some money gambling, if you have any contributions from relatives, all of that stuff has to be disclosed. IRA distributions, anything like that. And those can all have an effect on the means test. I mean, there's ways to get around that, but it's just something that has to be listed in your bankruptcy. For tax refunds, we ask those to be estimated, for a couple of reasons. For a Chapter 7 bankruptcy, because, hey, we have to exempt that. It's an asset. For a Chapter 13, it's considered disposable income. So we like to know going ahead, you might be able to put it in the budget. Who knows? In any event, the biggest thing to take from this is with bankruptcy, you're kind of, I've kind of learned this as I started bankruptcy, is we kind of need to know a little bit about all the areas of law. We need to know about real estate. We need to know about transfers, divorce. We need to have some knowledge about family law to deal with, property settlements, criminal law, so we can get an idea if that's a debt that, can be discharged or not. And it's just really important when you meet with these clients to get a full picture of their situation and really to know what has triggered the call to your office, because that can be something that helps you identify, all right, this is the best option for you. And you'll have some cases where they have so much in assets, but they have little to no income. And is a bankruptcy really a good option for them? You know, for example, I've had clients come in where they have, you know, 50, 60, 100,000 of equity in their house, but they're only getting Social Security disability, and they really have nothing else. They can't afford to pay these debts, but they also can't afford to make payments in a Chapter 13. And in those situations, bankruptcy may not be an option for them. It may just be you're uncollectible because you can't be garnished, and hopefully no one, you know, tries to put a lien on your house. But I mean, even so, like, it's difficult to foreclose in that way. So for some people, it might be that you can't qualify for a bankruptcy, or for some, it may be a debt settlement is a better option, just because with the amount of assets that you have, you would have to pay back 100% of your debt. So maybe let's try to work out some lump sum settlements or payment arrangements with your creditors and avoid a bankruptcy. But really getting the picture, the full picture of assets, income, and debts is what is going to help dictate what their debt relief options are. And like I said, it's not always a bankruptcy. It could be something else, but this is what gives us a good picture of, you know, what those options might be.
I have a question that came in.
Yeah.
If you have a bank account that is traceable entirely to Social Security disability income, is it an exempt asset in a Chapter 7 bankruptcy? It seemingly would be under normal creditor law.
Yes, it is. Yep, you can exempt any money that's from Social Security. You can also exempt Social Security back pay payments that might be coming in too, as long as it's traceable. I mean, where people start getting into trouble is when they're commingling the funds with employment income, and then it's hard to tell, you know, what's what. So it's better to keep it separate. Well, I don't have much else to say. So if anyone has any other questions, I would be happy to answer those.
I have one question. So what would you say in your experience is the biggest reason that bankruptcies are not successful?
Well, for Chapter 13 bankruptcies, the biggest reason is, you know, a job loss, some change in the financial situation where they can no longer make the payments as required. Chapter 7 bankruptcies are usually successful. I haven't had someone have their discharge revoked, but I mean, I've seen it happen. And in those circumstances, it's usually someone not being honest with their assets. You know, if you purposely don't disclose something that you have, it's not going to be good. You're not going to get a discharge, but they still might take your assets, and you might get hit with perjury, potential jail time. So, you know, I mean, there's definitely issues with bankruptcies, but usually, if you're working with a good attorney, they can figure out a way to negotiate that for you, even if it means that you have to enter into some sort of settlement agreement and make payments over time.
Another question is, since you do sounds like some probate work as well, what's the difference that you see in practicing in federal court versus the state courts?
Well, I will say in our bankruptcy community, we're a very tight-knit group, and I feel that you know, everyone knows each other pretty well, and I like that. There's 3 judges. We have a lot of seminars constantly. I like that. I'm probate. I'm not in court as much in probate like I am in bankruptcy. In bankruptcy, we're having motions, you know, every month, few days a week sometimes. So, I mean, I really like my bankruptcy side of the practice. I like probate too. I don't, there's not as much litigation, I guess, for me in the probate area as it is in bankruptcy. but both fun areas of law.
Well, thank you. It doesn't look like I have any other questions that have come in. So unless someone wants to throw one into the chat real quick or submit one, we will sign off here.
Great.
So thank you very much, April, for the presentation. Thank you, everybody, for attending. Thank you for all the great questions that you submitted. And I'm going to really quickly throw up my screen here. Just to remind people, if you haven't already, please complete the pro bono attorney pledge form. That's the web address there. You can find it on Legal Aid of Western Michigan's website. So, please pledge to take some pro bono cases. We always need more people. All the people that spoke today have taken cases and have given a lot to the pro bono program, so we thank them. And there's my information as well. Feel free to reach out to me if you have any questions or anything else you need. So we're always looking for new opportunities to provide you with more trainings like this, trainings on specific areas of law, so you can take cases that might be in areas you're less familiar with. But with that said, thank you, everybody, for coming today.
Thanks, Noah.